morning, councils. The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case number CVA19-022 in the matter of the guardianship of Yuclan Moylan. Appearing for the appellee, Lena Lealoha Moylan Alston, is attorney Jacqueline Taitano Terlahi. Appearing for the appellant, Richard E. Moylan, is attorney Douglas B. Moylan. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Moylan reserves 10 minutes.
Thank you. Mr. Moylan, you are recognized and you may begin.
Chief Justice, may it please the court. We take this appeal based upon 4 apparent errors of the September 27, 2019 decision from the Superior Court of Guam. The first error that we attribute is a notice defect that the Supreme Court had earlier opined on, although it was a 5-day requirement arising from the statute within the 15 GCA 3802. The second error that we allege is an ultra vires appointment of a special guardian with the court reserving in itself powers of the guardian. The third error that we attribute is the interpretation of the bond requirement, which goes hand in hand with the manner in which the appointment was made. And the fourth error that we attribute is the fitness of this particular petitioner that was granted a special guardianship. We note, Your Honors, that the September 27, 2019 decision changed the status of the ward from a limited guardianship to a full general guardianship. As part of the requirements changing that status, which was a 2008 status, which was changed in 2019 via that decision.
Mr. Moylan, why was it a change of status? The court, I'm looking at the order, still appointed Lealoha as the limited guardian of the person and estate of Mrs. Moylan. So, I mean, it was not a general guardianship appointment of Lealoha.
That is correct, Your Honor. That's why we focused upon what the court did. It found that Yuclan was in need of a general guardianship. She was no longer capable, and changing her civil rights status from having some control over her estate to having no control, no further control. And we believe that was the trigger that caused the change and the invocation of the Supreme Court's 2018 decision that spoke of the valuable civil liberties that were at stake and how important a strict construction of procedure was necessary. But yes, as to the characterization, the court identified Lealoha as a special guardian. The court did not make her a general guardian. And that goes to our second point. The statute is devoid of any reference to obviously making a special guardian is authorized, but then what do you do with the rest of the rights when a general guardianship has been imposed? And the court reserved in itself that ability to manage a part of the estate. And hence the...
And you say that the court reserved in itself the balance of the estate, that they didn't give authority to Lealoha to manage under what pretense? I mean, there was no specific conclusion by the court that the court was going to engage in that review and control, right?
Yes, but
you're just saying that that's the assumption that that was the case, that the court was going to exercise those powers.
Actually, in the decision itself, the court, by virtue of first finding a general guardianship was now needed, a change in the status, and then saying, Lealoha, you can have a part of the estate and manage it, and leaving devoid any further references to the rest of the estate, I believe by reasonable implication, the court was managing the estate because no one could touch the funds or the other assets of the estate.
But doesn't that also mean, Mr. Moylan, that if only limited authority is given to Ms. Elston, and the court did not grant the full guardianship, that then that the ward retains the remaining discretion in reference to how to conduct her life. I mean, in this case, we have a 102-year-old ward, but generally, if the court only grants limited powers to the guardian of the person and does nothing more, isn't it also reasonable to assume that that means that the ward continues to maintain some autonomy over how she's going to conduct her life?
Mr. Chief Justice, the decision, and I'm attempting to locate the specific statement, found that she was no longer in a limited guardianship status, but in a general guardianship. The lower court opinion decision clearly identified that because of her incapacity and her inability to manage her own affairs, that she now needed a full general guardianship. We actually contested it down below, saying that there was insufficient evidence provided, at least for purposes of depriving her of all her civil rights. But the decision is very clear that it did identify removing all of her civil rights for purposes of incompetency, as the statute envisions.
If you can point me to the language in the order where the court made that determination. I noticed that the court on at page 8 of its decision, talking about its own observations of her, indicated that that Mrs. Moylan showed no indication she was aware that the court proceedings concerned her, or that court proceedings were occurring at all. But I didn't see a provision that the court was essentially determining that it was going to strip her of any autonomy, as Justice Carbolito points out, over the remainder of her person and estate as otherwise was provided to Miss Alston or Lealoha.
And while you're looking for that, I am looking at the record. I point out that the December 20th, 2018, Ms. Alston filed a petition to become a special guardian of the estate, requesting for specific authority over accounts and certain financial obligations. And then the May 3rd, 2019, she filed a petition for a future hearing appointing a general guardian of the estate and another request for access to specific accounts. And then the court denied that. And what we have, what we have now before us is for a temporary limited guardianship. And so I'm a little confused when you say that she's now the general guardian.
Thank you, Your Honors. The way that I've looked at the record is that on December 20, 2018, the motion for special guardianship was filed. Then on May 3rd, 2019, the motion for general guardianship was filed. The general guardianship was a petition seeking to deprive her of all the rights that she had remaining from the 2008 determination by Judge Barrett Anderson.
Let me just point out that on May 14th, 2019, the court denied the December 20th, 2018 petition to become the special guardian on procedural grounds. And then when we proceed with the May 3rd, 2019 petition, which is what is in front of us now, and in reference to the decision of the court in setting that hearing down, which is what you are challenging.
Yes, Your Honor. Thank you. There's actually 3 decisions before the final September 27, 2019 decisions. And that goes to the notice requirement on 3802, which focuses upon the ward that any change in her situation was being sought. And that's why I say motion for special guardian on December 20, 2018, the motion for general guardian on 5/3/19. Those decisions didn't say that they're denied. They were talking about errors in notice. I think two of them talked about the 5-day notice requirement, and then they talked about the notice requirement.
But at the same time, they weren't granted.
Yeah.
That's correct, and that's why
And
I raised.
Actually, the court in its decision on May 14th did say the court will deny the motion because she didn't receive notice of the hearing. And that was the motion or the petition to appoint her special guardian of the estate. So the court denied that special guardian appointment that was filed in December.
Yes, Your Honors, and that's why in our briefs, we point out that if you follow the filing the motions and the decisions, opposing counsel should have refiled if that was the interpretation. If that wasn't because the court proceeded to have a hearing before the September 27th hearing, I believe it was around the June 20th date, that it specifically identified the problems with what had been going on, but nothing was refiled.
But Mr. Moylan, on May 3rd, when they filed the petition for the general guardianship and an ex parte application for the special guardianship, the court issued its decision that later, I think it was that denied or at least set a hearing for the general petition for general guardianship that had been filed. I don't believe, and the court caused the notice of the hearing, and I know you take issue with it saying guardianship as opposed to the petition for general guardianship, but the court noted that the general guardianship petition that was filed on May 3rd was the one that had been served upon her. And and I don't see anything that suggests, oh, you have to refile it, even though the court decides to not go forward with the hearing on the petition for general guardianship. In June 20th, the court said the petition for general letters was served on her on May 29th, and the guardian proceedings will be proceeding shortly for the general, which will result in a guardian of the estate for Mrs. Moylan. So, yeah.
Excuse me, Your Honors.
Go ahead.
What I guess these are all arguments going to the question of 3802, because we speak as lawyers as to tracking all these decisions and how to interpret it and which one was being removed or not. But I believe that when it comes down to the person whose rights are being affected, UCLON was never given what is normally required is a notice of hearing and the documents of what will be heard at that hearing together.
Well, the court said that she was provided these documents.
There is, and we concede that she was provided, she was served separately. And that's why I allude to our normal civil practice rules, that under that notice requirement that 3802 refers to, petitioner was obligated to provide her the paperwork contemporaneously with the notice of hearing. Yes, they did serve her with the 12/20/18 motion for special guardianship. Yes, they did serve her with the 5/3/19 motion for general guardianship moving papers, but they only served her finally with the court's July 23, 2019 hearing notice as a single document. And that would allude back to, can you serve a summons without the complaint, even though you gave the complaint earlier to an individual? And I believe that in the cases that were cited, that the rule requires a contemporaneous service. And especially, Your Honors, I allude to the fact that you have people, a group of people who are normally monomcos, they can be younger, but usually they're monomcos. They have cognitive impairments normally, and as not being lawyers to begin with, but to not require what we normally require in OSCs, what we require in subpoenas, and what we require in the normal serving of pleadings for especially a guardianship case is a breach of the requirements that the Supreme Court believed earlier in its decision for strict construction of procedure. So I
understand the argument, and the argument essentially is that when you serve the notice of the hearing, that you have to serve the petition at that time. That's essentially your argument.
And it would have cleared up all these legal arguments that we are having to forensically review the file with, Your Honors.
Okay, let's go on to the bond issue. That interests me a little here. Obviously under 3506 of the code, if there's more than one guardian appointed, there's a requirement that each of the guardians have to give a separate bond. Is it your position that when more than one guardian, this is more of a hypothetical than related to it, but I have a follow-up question to this. If there's more than one guardian that's appointed and has to provide a separate bond, what would be the bond amount that is required? Each guardian would be required to post the bond set forth in 4001, and that is that if it's done by a surety, that the value of the personal property and the rents, issues, and profits of all the property, so that essentially you have double the amount, or can the court split the bond and require each of the guardians to post the amounts the court require, as long as the amount set forth in 4001 is satisfied? What is your view on that?
Justice, my view is that the statute is very clear that if you have a situation of co-guardians, that you must have a bond equal to the full value for each one, because the co-guardians are the ones that have full management and control of the entire estate. The statute is silent as to what if the court breaks it in two. And that's why I say it's silence in the statute does not allow for reading in the legislative intent. And because the legislature specifically spoke to multiple guardianships, multiple guardians, co-guardians, that each one have the full bond posting.
So you think in that situation, I mean, that each guardian would be required to give the full amount set forth in 401, and the estate would have to incur that cost to pay for the cost of both those bonds?
For its protection, that is the way the legislature constructed their statute. And again, the Supreme Court has, in this case, opined that it is important to follow a strict construction of the financial requirements because it attaches to the welfare of the ward.
And let me ask you, in this case, you are arguing that Lea Aloha has to post the full bond required under 4001. What would that amount be? The statute sets forth that if you're doing it with an authorized surety company, it's the value of the personal property and the rents, issues, and profits of all the property belonging to the ward. Is cash included in the personal property? Generally, one wouldn't think of stock and cash as part of personal property.
In 2008, Judge Barrett Anderson, that is how it was calculated, based upon the personal property, which included cash. And Kurt Moylan was required to post the full bond for the personal property, based not on the real property, but it was based on the personal properties, which included cash. Your Honors, I also have that reference that the court was talking about on the decision, talking about her general guardianship appointment. It was a excerpt of record 209, line 17 to 18. The lower court determined that she is incompetent and in need of a guardian. A full incompetency equals a general guardianship under my reading of the statutes, Your Honor. Also, Your Honors, I would please reference this idea that the statutory construction of our guardianship statutes puts the judges and down below in the Superior Court as adjudicators of any issues, including removal of guardians. There is no exception for purposes of the court looking at itself. And also there's a separation of powers question that the court may have been taking on an executive function by enforcing the guardianship rules, that there would be no adjudicator in case the court had made a mistake. And because the court is, as the justices have pointed out earlier, is the judge actually managing the rest of her estate or not? Those are the questions that occurred because of going outside the statutory statements in the code.
And I assume in making that argument, you're making reference to the courts, what the court did here in ordering a limited guardian. And I'm having problems with your argument, Mr. Moylan, that if the court issues a certain authority under a limited guardian, in this case, you're saying it's only a special guardian. Functionally, the limited guardian operates as a special guardian, and that if there is additional duties, responsibilities that are left not addressed, that by definition the court acts as the special guardian in that case. I see it that it can also be interpreted that when the court doesn't grant the full panoply of authority or duties and responsibilities to this limited guardian, that reserves in the ward the autonomy that she can operate her life subject to the limitations that the court has issued, and not that the court vests in itself the power. The court continues, and that's the purpose of a guardianship, is to oversee the person in the state of the ward, subject to the appointments of its representatives through the guardianship. And so I'm just having a little problem with you saying that by default that then the trial judge is acting as the co-guardian, because it did not grant certain full powers to the limited guardian.
Chief Justice, I do agree with you in terms of who is actually responsible for the remainder of the estate. And again, I focus upon, because the court makes several references that she's just sitting there looking at her paper, going back and forth, looking at it. The court went further and says she's now incompetent. Once the court triggers that incompetency, she can't manage her estate. She has no right to go down to the bank and say that I want to move these funds that were in my savings account, because someone can come in and show the bank she's legally incompetent and no longer has that authority. But then at the same time, the special guardian does not have that authority, because the judge said to her, you only have this amount of control. So under the statutory scheme, whether the judge below reserved power to himself or not, there's a void now on who is to manage that estate, the remainder of the estate. And that's why I say it's ultra vires, because it falls outside the answers that the statute can provide. And I do that with respect. I'm not trying to attribute anything that's not attributable to the lower court, but it appears to me that then who would be responsible? And what happens if the bank itself mismanaged it? It just leaves the question on then who is.
And that issue is not before us on appeal. If the court had rejected the general guardianship, and the petitions that are being entertained are only for special guardianship over the person and the estate, and the court then addresses the needs of the ward and just what it will take to provide for the care of the person and the estate of the ward, then to me, the court has, in listening to the facts, has made the determination that this is all that is needed to protect the ward, and reference that she can continue to live out her life. And if you say, well, the judge pointed out that as a result of how she was acting in court, that to me, there also was that observation that you required that the ward be personally served, and she was served with 12 different documents, and she's just thumbing through it. So there's also the practical effect of adhering to the rigid language of the statute. But we upheld that the ward is entitled to this notice, and so that needed to be carried out. But we also have to be mindful of the spirit of these guardianship proceedings and the flexibility that I think is needed to be granted to the trial court in managing the day-to-day lives of persons in need of protection, and at the same time recognize their autonomy and rights to make decisions on their own. And like I pointed out, in this particular case, the facts is we have a 102-year-old woman who we're talking about. And so, we need to have some common sense in reference to how we apply these statutes.
Yes, Your Honor, Chief Justice, I do also, and that's why the third issue dovetailed into the second issue, the bond issue, that if in fact that Lealoha is only bonded to the amount that she was given authority over, what happens with the rest of the estate security? And I wouldn't be making this argument if it wasn't the way that I had seen that Excerpt of Record 209 in the decision and order of the lower court. The court found that she was incompetent. We fought against that at the hearing, saying that there's insufficient evidence. They haven't presented the appropriate doctor's reports. And she wasn't even put on the stand because she wasn't provided dentures. But it wasn't like she was just sitting there, as the court had noted in its decision. She was showing activity. And again, we're not saying that she's totally incompetent. We're not saying that she is competent. But the procedure that 3802 required, in our humble opinion, was not followed. But the court, Chief Justice, you raised the appropriate questions.
Yeah, let me go back to this issue of the bond amount, and in examining, even under the argument that the court is required to get the value of the personal property and the rents and issues and profits. If you look at the total amount of the rental income that's generated by the rental properties, approximately, I think the court said between $5,000 to $7,000 a month. So, if you say it's $70,000 a year, and if cash, just assuming for purposes of this discussion, is not included in the calculation of personal property, I know that you indicated that prior judge determined to include cash as part of the definition of the bond requirements. There's been no determination of what Mrs. Moylan's personal property, a part of cash is, that's in here. But if you look at then the rents and profits that are generated, and interest income as an example as a rough estimate of 3% on the total amount of the cash assets that's held, it seems that the court's establishment of the $150,000 or $250,000 bond might be sufficient to cover all of the rents, issues, and profits and the value of the personal property if cash is not included.
The only issue I see with that is that in reality, we're talking about liquid assets. In this case, particularly, those liquid asset deposits were taken from her by the caregivers.
Although she had no access to them currently. The court specifically limited her, Lealoha's access to those amounts. But even if that was the case, if personal property does not include cash and stocks and bonds, then one would, even at the full value of the estate, without an understanding of what the total personal property is of Mrs. Moylan, jewelry, etc., it appears that the court may have been fine in setting the amount it did.
For purposes of breaking the estate up the way that the court did, I believe that the court was looking at the cash value, as Judge Barrett Anderson had earlier, and was attempting to provide sufficient security in case there was any mismanagement of the estate. I do agree there. It's just that the statutory requirements don't provide for that. And I would suggest to the court that it has to be cash, the personal property that the statute talks about, because that is the most transferable, that is the quantity that would be most likely taken, would be cash. When the courts talk about rents and profits, those are cash. Those are reduced to cash currency. So if I'm answering answering the court's question, I believe that the court did provide for Lealoha as to what it provided that she control. That is what the court intended to do by requiring her to do a limited surety bond just for the estate that she controlled. Your Honors, may I reserve whatever left?
Yeah, I know you have 53 seconds. We'll stop the clock there.
Thank
But
you.
because of this vigorous questioning, I'll give you a little more time, Mr. Moylan. But at this
Thank you.
time, I'm going to recognize Attorney Terlai. Jackie, you are recognized. Attorney Terlai, you are recognized.
May it please the court. There's no dispute in this case that the 102-year-old ward required the assistance of a guardian. The guardianship court in this case correctly designed the levels and limitations of the guardianship, acting in her best interest. And in the context of both the bond, the appointment of Lealoha Alston, and in a finding that she was in need of a guardian, were all appropriately taken into account, considering the 12-year record that has been developed in this particular case. And so, Your Honors, I'd like to address
Mr. Lai,
some
let
of
me
the-
ask you this. Who's managing the rental of this ward? Who's handling the ensuring that tenants are found, that maintenance is upheld, all of that for the rental properties that this ward has?
that
Clearly
duty
can't be
has
the ward.
that duty has been granted by the court to the limited guardian. I would point out for this court that the record indicates
I
that
thought the
full
limited
rental
guardian
amounts-
only had the authority to pay gross receipts tax, real property and income tax, and do the general business as set forth in the guardian's quarterly reports.
And that's absolutely correct, Your Honor, which is why the 12 years of quarterly reports that are on record are extremely important in the determination of the scope and the powers that are granted to this particular limited guardian. The court can review those particular quarterly reports at the record transmittal of record 561 through 564C. In those particular quarterly reports, what you see is that the ward does not own 100% of the rental incomes derived from real property. The real properties are common interest ownership, and as a result of the common interest ownership, a portion of the rental is in fact owned by the ward. That portion is deposited into her account, and then that portion is a gross receipts tax is paid on that as well. The real property taxes are also paid. So that's part of the trust duties that had been granted to this particular limited guardian, is to ensure that those rental amounts are in fact being utilized for this ward. And as the court can see from the consistent quarterly reports and annual reports that have been filed, there has been a detailed accounting of all the rents that have been received by the ward. And that's where it takes me to this issue of the trust duties of the guardian. What trust duties was this limited guardian given? Because that question is extremely important in determination of the posting of the bond. If the court looks at section 4001 of Title 15, it says specifically that the bond should be determined to require the guardian to perform the duties of his office. So the first question the court must ask is, what are the duties of the office that were imposed by the court on this limited guardian? The duties imposed included the rents, included the payment of taxes, included specific accounts. And so as a result of taking into account the duties, the guardianship court correctly determined that the value of the bond that was required to be posted would be $250,000, because that is based on the quarterly and the annual reports that confirm for the court the amounts that are received in rent, the amounts that are received from various income sources for the ward, and taking all of that into account in addition to the bank accounts that are made available
But
specifically to this
I
limited
could
guardian.
interrupt at this point, Ms. Attorney Terlai. Well, what you say may all make very good sense. We are restricted to the statutory scheme specifically in the bond requirement, as Justice Torres has honed in, the requirements are set out in 15 GCA 4001. And I don't see anything in 4001 that the posting of the bond is tied to the responsibilities of the limited guardian or special guardian in that case. I think the statute is pretty specific in terms of the formula that needs to be used when the court is determining the posting of the bond, whether it be a general guardian or a special guardian. And when the bond is given by an authorized surety company, it shall be not less than the value of the personal property and the probable annual rents, issues, and profits of all property belonging to the ward. And so while it may make sense that when you're trying to protect the assets of the ward, that you tie it into its responsibilities and what's the maximum damage that he or she can cause if there's an abuse. However, the statute doesn't say that. And so I'm having difficulty in correlating what the trial court did here, as Mr. Moylan points out, with the wording of 4001. And unless you can point me to some other statute that then says, but if we have a limited guardian, we can reduce the bond amount to only what is at risk in reference to the duties and responsibilities. And so I don't know if we have that authority to rewrite the statute in reference to how is it that you are arguing.
That would be correct, Your Honor, because if the court looks specifically at only 4001, 4001 is specific to the duties. So according to the second line of 4001, it says the person appointed must take an oath which must be attached that he will perform the duties of his office as such guardian according to law. And if the court looks further into the statute, towards the end of the statute, the purpose of the bond is conditioned so that the guardian will faithfully execute the duties of his trust according to the law. So when the court looks at what is there in 4001, the court cannot also ignore Section 3506 of Title 15. Section 3506 provides that the court in its discretion may appoint more than one guardian, each of whom must give a separate bond and be governed and liable in all respects as a sole guardian. So in this particular instance, the sole guardian per se, in conformance with this statute, on the duties and obligations of this limited guardian is limited to the specific accounts and specific rental amounts. And so when the court
4001, Mr. Lahi, doesn't look at, as the Chief Justice points out, doesn't look at the property that is subject to the duties of the guardian's trust. It looks at all the property belonging to the ward. That's the definition that's set forth in the statute. The statute is not the property that the guardian has trust over, or the property assigned to the guardian who will be performing his duties over that trust. The plain language is all property belonging to the ward.
And that's the very reason why this court needs to review the purpose of the statute in terms of what its stated purpose is. As this court has already recognized, the purpose of the bond is to ensure faithful performance of the guardian. So if the bond requirement is to ensure faithful performance, it begs the question that the court must look to what the trust and duties are of that guardian as set forth in this specific statute, that it's for that guarantee to ensure that the guardian is performing their duties as required. And so
is it possible that the court could use the powers that are provided to it under 3501 to modify the requirements of the bond under 4001? That specific statute 3501 says that a guardian, the management and disposition of the person or property committed to him, a guardian may be regulated and controlled by the court. Do you think that statute provides some autonomy for the trial court to, in looking at the management and disposition and regulation of the guardian, to be able to make an interpretation of 4001 in the manner that you suggest?
Yes, Your Honor, I think you're absolutely correct that the court needs to have some basis in which to act. And so we cannot look purely at 4001 in a vacuum. The court, the trial court in this instance, is required to take as a whole its obligation and duties once a guardianship proceeding is put before it. So to limit the guardianship court to only the value of the total assets of the estate would probably disqualify a large amount of potential third-party guardians who the court wants for incompetent wards. So I use an example. There is $10 million in cash assets owned by a potential ward, and the court decides that they're not going to give access to any guardian of the $10 million, but only wants to give a limited power of $1 million in one particular account. Well, since a guardian does not have access, the guardian cannot faithfully perform any duties related to the remaining $9 million. And this is the reason why I say we must go back to what the obligations are placed on the court, and 3501 in conjunction with the entire guardianship schematic that is laid out in Title 15 sets forth that the purpose of the bond is specifically to ensure faithful performance by that guardian. And in this case, the trial court has adequately taken into account and correctly taken into account the fact that this ward needs a guardian, she needs assistance, and that assistance is specifically tailored to the facts and circumstances of her case. And so I encourage this court, and I urge this court to look specifically at the powers that are granted to the guardianship court to determine the level of guardianship that's required, to determine the limitations. And in this particular instance, the trial court did that. The trial court, acting in the best interest of the ward, determined that only specific accounts and rents would be available to this limited guardian and appropriately required her to post the bond related to that particular amount.
How do you reconcile the trial court's determination that she was incompetent and in need of a guardian, what appears to be a general guardianship finding, with only an appointment of a special guardian? I mean, the expectation clearly was not that Yuclan would have authority over the remainder of her person and estate, right? And so in this case, I mean, obviously there's cash, and one could, I presume the argument will be, well, there's no need to manage that cash. It's going to just sit there in the bank and earn interest, and it would continue. But if that wasn't cash and it was stocks, and there were investment decisions that had to be made, and the court did not want to, for maybe some of the same reasons it didn't want to permit Lealoha to have complete access to the entire estate, decided not to appoint her responsibility over those stocks and bonds. Who has the authority then over that? Did the court not go far enough in appointing a guardian over the remaining assets that that the court did not give Lealoha authority over? Somebody's got to be responsible for that.
And you're absolutely correct, Your Honor. Someone has to be responsible for it, and that's why there are interested parties involved in guardianship proceedings. A friend of a potential ward would be allowed to ask the court for assistance, which has been done in these proceedings for the last 12 years, more at this point, 12 years dating back from the September 2019 decision. So in terms of putting ourselves back at where the trial court was at that particular moment, the trial court had before it all the information it had gathered in 12 years. So what it had gathered is the fact that there exist other accounts What it also could gather is the fact that whenever there was a need greater than the monetary assets that were immediately available to the limited guardian, they simply made an application to the court, which was consistent with the guardianship statutes. So if there is other assets that belong to the ward that could be utilized in the best interest and the well-being of the ward, then an application to the court must be made. A good example of that is the sale of real property. If the court notices the real property value is not included in section 4001, and that's simply because that takes into account the scheme that is set up in the guardianship proceeding, that if you want to sell real property, not only do you have to apply to the court, but you also have to get an additional bond. So if in the instance where the limited guardian does not have access to the sale of real property granted by a court, a general guardian also would not. So in this scheme that has been put forth by the legislature in Title 15, a sale of real property, one, would require you to go to court and ask the court for specific permission and post an additional bond. In the same instance,
so can you answer my question? If the remaining assets was instead of cash, stocks and bonds, how is that going to be managed?
It would be incumbent on the parties involved to seek a specific order from the court for that particular power, which has been done in these particular proceedings. Every time that there was a need that is outside of the limited powers granted to the guardians, the parties simply requested from the court a specific power. In this case, there are no stocks and bonds.
Mrs. Pillai, wasn't it an abuse of discretion for the court not to provide for the proper management of all of the personal property, whether it's in a cash account or not, especially here where you have rental properties? They need to be managed. And I would suggest there was an abuse of discretion in the court failing to properly provide a guardian of the estate.
And Your Honor, I respectfully disagree, because what you have in these particular proceedings is 12 years of record. And this is why I point the court to the excerpt of record, specifically the findings of fact. And in that particular proceeding, you see that the court says, I'm also giving the power to the limited guardian to perform the general business as defined in the reports. And so if the court takes a look at the findings of facts and conclusions of law, what you'll see is that the trial court, the guardianship court, has taken into account that there are many things that the limited guardian can perform and has performed, and has ordered that she continue to perform the general business as reported in those quarterly reports. So I disagree.
I noticed in one of the audit reports, for example, there's an amount that exceeds the federal deposit insurance limits in a particular financial institution. Shouldn't there be a general guardian who's saying, oh, now we have to move the excess amount to another financial institution? Nobody seems to be doing those kinds of things. Nobody seems to be managing her interest in the property. Isn't that an abuse of discretion in the court's failure to act?
And I don't believe, taking into account the facts in this particular case, that would be an abuse of discretion, because the trial court in this instance has made the effort to ensure the balancing of the rights of the individual ward and taking into account her need for assistance. So in this particular instance, there is no evidence in the record that there was a need for a guardian to manage that type of information. So for example, the TCDs, there's no TCDs that are deposited. There's no information at the lower court level of information of the FDIC amounts being exceeded in any particular financial institution. So whether or not that amount is $500,000 in one account or $12 million in another account, that simply was not before the trial court. And so the trial court did not see a need to appoint a guardian for that particular purpose. And that is the reason why it's extremely important that this court remember that the best party, the best person sitting to make these types of determinations about the needs of the ward is the guardianship court in the first instance, because the guardianship court is the court that has all the information before it. And so taking into account all the years of information and the reports provided, it appears that the trial court and the guardianship court from its order, its final order of—
We lost Justice Merriman.
If we could just pause. Can you just stop the clock, Karina? And let's just try and see if she's going to try and log on first, and if not, she's going to call in. So if we can just pause, Attorney July, just for a minute. And you can note in your notes your train of thought of how you want to continue, but I apologize. As we said at the outset, it's great when it works, and technology, we're at the mercy of technology when it doesn't. I'm going to go offline, just mute myself so we can ask Justice Merriman if maybe she just call in. So we have the clerk of court contacting Justice Merriman to ask her to just call in. And so if we could just be patient for a few minutes.
We were just talking about technology.
That's right. Great. I can see you, Justice Merriman, and it's just your audio now.
I'm sorry, my internet went out.
We're good. And I think CJ, Jackie can proceed.
Yeah, I was just responding to our clerk of court. So Justice Merriman is back on. And so Attorney Terlahi, you can go ahead and proceed.
Thank you, Your Honor. Before we got disconnected, Justice Merriman, I was answering the question about related to the management, the abuse of discretion issues, and I was urging this court to allow a guardianship court to sit who is sitting in the best position to make determinations of facts. In this particular instance, this court can review the record. The transmittal of record designation is 564C for the annual report, an example of an annual report that has been filed in these proceedings. So as part of that annual report, what you see is a detailed listing of the property tax payments, the gross receipts payments, the rental income, the statuses of what the rental income receipt is, and which hence takes into account all of those details as part of the limited powers granted to this limited guardian. And I say that why? Because if the court reviews the excerpts of record at 214, and it is section A4, it says specifically that the limited guardian is granted the power to transact all the general business of Yucla and Moylan as set forth in the quarterly reports. So it's important to take into context what the trial court was doing in this case. The court was taking into account the quarterly and annual reports that have consistently been filed as part of the business transaction and the power that is being granted to the limited guardian.
I don't disagree with you that the court has a lot of flexibility, but I'm concerned that the court here may not have properly exercised that authority. It is possible to have guardians of the person, guardians of the estate, with various different authorities and powers. And I'm just suggesting, I'm concerned here that the court may have neglected to take care of one of the most important parts, which is providing for the management of the estate in its entirety. Which is why I'm concerned about how this appointment was made.
And Your Honor, I appreciate the court's review of it. And this is the reason I also encourage this court to review the findings of fact, specifically as it relates to that question that the court is wondering about. Because if the court reviews excerpts of record 211 to 212, the trial court specifically addresses Lealoha's ability to manage the estate. So if the court reviews that, the court basically is taking into account the proper management of the estate, what decisions need to be made, and the court specifically makes a finding that Lealoha Alston is capable of managing the estate, and as a result, the court has granted her the powers, the limited powers. And the limited powers that were granted herein include a portion of the management of the estate. So the reason she is designated as a limited guardian as opposed to a general guardian, that what we typically understand it to be, is because in this instance, the trial court was limiting access to particular funds. And so if this court looks at the limitation of guardianship in that context, every guardian who is limited in any aspect is considered a limited guardian and not a general guardian. So even if the court granted nearly a general guardian power, but restricted access to one asset or another, that person is no longer a general guardian, but they're a limited guardian. And this is the reason why the statute in section 3501 provides specifically for the court's authority to properly manage and review. And I think that that's an important key word there in the statute is review, that the court does in fact have an obligation to address any issues that are brought before it where there is a lack of management perhaps. Unfortunately, that issue is not before us on a particular lack of management issue, but I think that the authority is granted there under section 3501 in this context as well. And so,
If she
Your
has
Honor,
that broad scope of authority, why doesn't she have to post a bond that covers the entire estate? As required
she
in
does
accordance
not.
with Tier 1.
And the reason why she is not required to, according to the trial court and according to 4001, because her performance of duties are restricted. So the performance of duties needs to be taken into account under 4001. And this is the reason why 4001 says that the performance is the bond so that the guardian can faithfully execute his or her duties. And that's the very reason why I have offered to the court, and I have urged this court to consider that taking into account the entire guardianship scheme and the requirements to post additional bonds where there is an impact of the sale of real property, or there is the touching of additional assets related to the estate that are not covered by the guardianship, that an additional bond is in fact required. So should the court give access to $1 million to the limited guardian, then it would be appropriate for the court to increase the bond. Why? Because that scheme is also permitted under our statutes. Now, Your Honors, I also wanted to address the issue of section 4003. That's in conjunction with what I am offering to the court as the additional bond that would be required. 15 GCA 4003 provides that a guardian must furnish such additional bond. And so where there's a sale of property or there's a receipt of cash assets as a result of the sale, a guardian is required to furnish that additional bond. And so that is the very reason why I say taking into account the whole of the statute, when the court looks at the bonding requirements, what the court can see is that there is an additional requirement once a guardian is given greater access to assets of the estate. Your Honors, I don't know if you wanted me to touch on the issue of notice, but what I think is extremely important on the issue of notice in these proceedings is that there is no dispute that the ward received the notice as required by section 3802. What the appellant is requesting that this court do is impose additional requirements, to read into the statute additional requirements that are not there. And what is required by section 3802 is that the ward in fact receive notice. In this particular case, and in all cases, if the court has not set a particular matter for hearing, then we have no ability to serve the notice. And so serving of a petition is already the initial notice that is being given to a potential ward, that they are being asked to be brought to court on a guardianship proceeding. So the filing of the petition and service of that petition acts as a first level of notice. The secondary notice is the notice of hearing related to the guardianship. And as the court has already pointed out, that particular notice specifically states that this is in relation to the matter of the guardianship of Guardian Moylan in the caption. And further, in the body of that particular document, in document ER 200, it also states that the purpose is for guardianship. So in this particular instance, Guardian Moylan did in fact receive notification of the notice. I'd also point out for the court what's important on the notice issues is the presence of Mrs. Guardian Moylan. In this particular instance, Mrs. Moylan was present for the hearing on July 23rd. She was present on June 4th, 2019 for a scheduling conference, and she was present again on May 10th in 2019, wherein in all of those proceedings, there was a discussion specifically about the scheduling of the guardianship petition. And so based on that, I would offer to the courts that in this particular instance, there has been an absolute good faith and strict compliance attempted with the notice provisions issue.
I
Well,
also,
as I said,
because of your limited time, if you could just touch on a major part of Mr. Moylan's argument is the appointment of Ms. Alston as the limited guardian, and he points out that there were abuses in the past of her guardianship position, and why would we sanction someone who has been found to abuse the guardianship position in the past to continue in a, although in a limited guardian capacity? You may want to just maybe touch on this.
Yes, Your Honor, I'll use that time that I have left, specifically because this court has already determined that that particular event was not with ill will. That was the issue that was already addressed in the first Supreme Court appeal in these proceedings. And there the court found that because that there was no ill will, no intention to deceive, then therefore it was appropriate to appoint her as the guardian of the person. Likewise, it applies in this instance.
I see that your time has expired, Attorney Terlahi, and I thank you for your arguments and being patient in reference to our IT challenges. So before I recognize Mr. Moylan in terms of the remaining time in his rebuttal, can the clerk please just indicate how much time he has remaining? So that is the time, 50 seconds. Well, Mr. Moylan, we'll give you a couple of minutes to wrap up, and so you may go ahead and proceed.
Thank you, Chief Justice. In addition to what has been said, the lower court failed to do a timely inventory in calculating the bond. Back in 2008, Judge Barry Anderson spent great lengths to calculate based on the Steffi report, and that's why she engaged it. If the courts review all the reports that were filed by Alston, they fail to follow generally accepted accounting principles. No one can make sense of how she throws figures out here and there. There is no rhyme or reason if you look at those reports. It talks about nice photos, but then it goes into here and there on the assets of this estate, which further warrant that an inventory should have been performed, a proper inventory by an accountant. Robert Steffi is still engaged by the ward. The Section 3501 that the court was looking at, it just talks of management and disposition of property. It makes no reference to how the bond is calculated. And that's why I would reference our excerpt of record 121 to 128, a prior decision of this high court on June 24, 2008 on this case, where it strictly construed that language within the 4001 bond requirement. I would also note that if it was read liberally on Section 3501, then the court could literally just waive the bond requirement. And again, in the court's earlier pronouncement, there is no authority for the court to waive a bond requirement. So the construing 3501 in a broad fashion will actually conflict with a 4001, a very precise formula that the legislature to protect the ward's interest, best interest. I would also note that the prior guardian of the estate went through extensive hearings in terms of his background and education and training and experience in determining that Kurt Moylan was the best person to manage the estate. This is not an estate that just collects rent. It manages properties, it has business holdings, commercial and personal, which have not been addressed based on the years of not having a guardian of estate, a qualified guardian of the estate. Also, at the hearings, in terms of the notice requirement, the ward was never asked if she waived the personal service requirement in the way that we had read 3802 to require that notice actually receive the memorandum motion along with the notice of when that hearing is to be held. Yes, she received documents, but they were sporadic and literally over more than 6 months when she got the first document until she finally received the July 2019 hearing notice. I
I'm
would,
going to ask you to wind up, Mr. Moylan.
thank you. I would urge the justices, if you would please review the 3 cases, Jacobson, Decker, and Rich. They specifically address the fitness of a guardian and being appointed, and they all resulted in having a third-party financial institution do the estate management, which in this case, our code does provide for that as well. Thank you, justices.
Thank you, Attorney Moylan, and thank you, counsels, for your vigorous advocacy of your clients' respective interests. At this time, we've completed our oral arguments. The court will take the matter under advisement and will issue a written opinion at a later date. And so with that, the court stands